Good morning, good afternoon, good evening. Welcome to the fourth webinar in the series Acute Dispute and Underlying Conflict, co-hosted by JAMS and FCIArb. Please note this seminar is being recorded and will be available on YouTube approximately a week to two after the webinar. So, what does law mean to you? In my experience, your context, your profession, your life experience will mean that you have very different connections and answers with this question, even if you're a lawyer. And if you're not, then the field's even wider. I'm therefore going to, maybe controversially, start with three very simple definitions that hopefully you'll be arguing with in your own head by the time I've finished them. So, international law is a body of rules established by custom or by treaty and recognized by nations as binding in their relations with one another. Human rights law is an individual's rights and freedoms which form the basis of a relationship between the government and the individual. And it's worth highlighting in that context three broad areas of these rights: civil, political, socioeconomic, and collective developmental. And commercial law is the body of law that applies to the rights, relations, and conduct of persons and businesses engaged in commerce. So there's an interaction between both public law questions in relations between individuals and the state and private law relations between individuals and institutions. So the interactions and domino effects of changes due to the exigencies of war, armed conflict, pandemics, the climate crisis are huge. And people who are not normally directly invested in the commercial context may become more acutely aware of its public as well as private legal nature. And those normally involved in the civil commercial context may well become more aware of the fallout of public law elements in the commercial context in the ways that you didn't previously think about. So crisis situations, in short, lead to forced changes in legal practice, and at times to changes in the law itself in the form of international agreements, the Paris Agreement, for instance, around the climate crisis, legal treaties such as the Singapore Convention relating to mediation, and changes in legal practice arising from information and research on dispute resolution processes, such as Frau Konitschke's exit work on investor-state mediation. So in this fourth webinar in our series, we're focusing on civil, commercial, and international law. We brought together three speakers working in three different regions around the world with very different experience of interaction of civil, commercial, and international law in different contexts. My name is Isabel Phillips. I'm Director of ADR and Mediation Development at the Chartered Institute of Arbitrators. My practice has straddled the commercial and the political context, a conflict specialist and mediator both in commercial and fragile and post-conflict environments. And I'm co-moderating this webinar together with Niki Borofsky, who I will introduce shortly. The format of our webinar is it's going to be about an hour and 15 minutes long. This short introduction, followed by an introduction from Nikki, thoughts from our three speakers briefly, and then discussion and Q&A. So please do start adding questions in our Q&A tool right from the get-go. And use the chat function for general discussion and for any technical problems you might have. So on to our speakers, and I invite our speakers as I introduce you, please do come on camera. So, and I apologize in advance for my pronunciation. My Spanish is not ideal. So Ana Gerdau de Borja is a senior associate at the Gerdau in Paris, having spent more than 12 years of domestic and international arbitration experience. She currently acts as vice chair of FCIArb's Young Members Group Global Steering Committee and is co-chair of the Rising Arbitrators Initiative. She also acts as coordinator of Track 5, responsible for the Americas of the ICC Task Force on Corruption in International Arbitration. Welcome, Anna. Francis Xavier is a regional head of the disputes group of Raja and Tam, which is the largest regional law firm in Southeast Asia. If I remember rightly, they have 12 branches across Asia in 10 different countries, I think was the number. So he's also a past president of the Chartered Institute of Arbitrators and the Inter-Pacific Bar Association. Welcome, Francis. Finally, Victoria Marquez-Mees is a Mexican economist, is the EBRD's first chief accountability officer and responsible for addressing environmental and social conflicts in bank-funded projects. The EBRD provides funding in 39 countries in Eastern Europe, North Africa, and Central Asia. Prior to working for the EBRD, she held a similar role in the Inter-American Development Bank Group, overseeing dispute resolution processes in the LAC region. So, the speakers and I are joined by a co-moderator. Just before I introduce her, I'm going to just ask you a quick poll question. And that's going to flash up. I'd like you to take a moment to answer that. So, in which the following ADR processes do you have direct experience? In any role, whether party, neutral, advisor, and so on. So, just while you answer that, I'm going to introduce Niki Borofsky, Senior Global Practice Manager at JAMS Solutions. She's an attorney, mediator, a promoter of creative, thoughtful dispute resolution processes. Prior to her role as Senior Global Practice Manager at JAMS, she was Vice President at the CPR Institute. She's worked in-house at Alstom, as well as in the international arbitration practice at Latham & Watkins and Cosgar in Paris, France. Welcome, Nikki, and over to you.
Thank you so much, Isabel. As you continue to fill out the poll, I'm just going to launch into my very brief introduction to get everybody up to speed and to make sure that we're working with the same kind of background. It's really a continuing pleasure to be able to participate in this wonderful series with the Chartered Institute. You know, amongst the three definitions that Isabel started with, JAMS is much more centered on the commercial law portion, but the other two, international law and human rights law, really do impact our day-to-day as well. I wanted to just start out with saying, acknowledging the brain child. This webinar is the brainchild of my former colleague Ronce Howell, and thank him for bringing this series to life as we really do probe into the discussion in our fourth installment and turn our conversation to the impacts of acute dispute resolution on commercial, civil, commercial, and international law. We have a bunch of great speakers, so I'm going to try and be relatively speedy in my overview. Just for the context of where JAMS is coming from with getting involved in this kind of a global conversation. And I want to say also, it's great to see all of your chats coming in from all over the world. It makes me feel like I'm hosting a fabulous YouTube or Instagram post, and we're all really having the chance to communicate in a really lovely way. But this series really did grow out of our business disruption working group that we formed at the beginning of COVID. And it really is all about, for us, anticipating the needs of clients for innovative, cutting-edge dispute resolution and options. And again, the point of this series is about listening, adapting, tailoring, and training. So I really encourage you all to participate as much as possible through the Q&A and through the chat. The framework on which this series sits is really a roadmap and analysis of dispute resolution in times of conflict. We were guided by questions of what, where, who, why, and when. And it's really about recognizing the context that underlies our daily dispute and conflict resolution practices and challenges. In the last webinar, Jane Gunn asked, are you comfortable? She says that's a question that she regularly asks her clients. And she said the proper response these days, and I'm sure you're all feeling it, is probably not right now, because we really do find ourselves living and working in a canvas of conflicts: pandemic, geopolitical instability, environmental pressure, social unrest. And so our aim really is to bring together as diverse and experienced a group of speakers and experts to talk about how ADR practitioners can understand and learn in this context. So I'm going to kind of whiz through sessions 1, 2, and 3 for those of you who were not able to catch them. They are on YouTube, and you will have the links to understand the possibility for actually watching them after this if you're interested. We had Michael McElrath, who highlighted a bunch of things that occurred post-pandemic and in the context of rising political conflict and war. And one of the things was the importance of using an enterprise risk management perspective in ADR. We saw the power of going virtual and hybrid for resolving conflicts, and we saw the effectiveness of this modality. So the need for speed has been there always, and we've proved that it can happen. So this is one of the impacts. Sheila Bates really opened our eyes to the fact that we're living in a continual conflict reality. And that there's more shared risk taking, and our new normal really is going to be crisis laid upon crisis laid upon crisis. So let's get used to it, and let's figure out ways to learn from the past and the present to adapt better. Our third panel, or our second webinar, really had a great discussion with Tim Hardy, Alina Pereplinsky, and Karolina Jakovits, and I'm sorry for mispronouncing everybody's names. It's really a global exercise in pronunciation, but talked about the importance of facilitation in the process of dispute resolution, the understandings that we need to have of the psychology and ways in which the individuals who participate in disputes and are in the midst of conflict are being impacted by the world around us, and really an openness to engage with the emotional aspects of disputes and the human aspect of being in the midst of crisis. Our last webinar, which was number 3, brought together Laura Abrahamson, my colleague here at JAMS, from an arbitrator's perspective and former corporate counsel, to talk about the need for speed and the need for choosing pathways that can maximize the capability of enforcement. Jane Gunn, who I referenced earlier from FCIArb, spoke with her mediator's hat on and talked about the role that stakeholders have in anticipating, analyzing, and adapting, and taking the time to really go through these steps, especially in moments of crisis. And then Molly brought her great research on the potential roles that the private sector could have in helping to promote peace and conflict resolution. And in particular, she stressed that her research has shown that the public sector can really be useful with governance gap filling, being a proponent of peaceful negotiation without having an opinion on the end result, just supporting the process itself, and also helping with the implementation. Once an agreement is achieved, it's often costly and difficult to implement it, and that's a role that has been successful for the private sector. So today, our objectives are to offer you practical advice from experienced dispute resolvers on the challenges facing international commercial law and dispute resolution coming out of the current situation. So at this point, Katrina, I'd love to launch our next poll and ask the participants to just talk a little bit and share a little bit about your own experience with dispute resolution. And as you fill this out, I'm going to just continue on with multitasking and just reinforce that this webinar series is really about listening, acknowledging, learning, and responding. And it's an iterative process and a discussion that we hope goes beyond just today's webinar and even beyond the series. So I really look forward to your participation. I think that we can all agree that there's a lot of things going on. So in this state of confusion, our hope really is to help provide roadmaps, resources for organizations and practitioners around the world so that we can have that big box on the picture as we try and put together the puzzle of what works best in these very challenging times of acute crisis. That is all I have for you right now, and I'm very happy to pass the microphone back to Isabel and get on to our main event here with our fabulous speakers. Thank you so much.
Thank you, Nikki. So without further ado, I'd like to welcome Anna to start the ball rolling with her brief presentation Over to you, Anna. I can hear you, but I can't see you.
Yes, I cannot activate my video. Okay, so thank you.
Wonderful.
Hello. Okay, good morning. Thank you, Isabel. Thank you. Good morning, good afternoon, good evening, depending on where you are on your time zone. Thanks again to Mrs. Phillips, to Mrs. Gallagher, and to Mrs. Borowski for the invitation. And thanks to FCIArb and to GEMS for hosting this event. It's a great honor to participate in this webinar alongside such talented colleagues. Today, I will discuss with you some repercussions of the war in Ukraine on business transactions and some dispute resolution trends from an European and Latin American perspective. As I come from Brazil, but I'm based in Paris, France. We have witnessed since February, March this year, a surge in events arising from the war in Ukraine. First, I'll give you a few examples. First, Ukraine's seizure of assets belonging to Russian banks. Second, seizure of foreign-owned planes leased to Russian airlines. Third, limitation on the transfer of funds out of Russia and to Russia. Fourth, special procedures instituted by Decree number 172 of 31st March 2022, related to gas sales contracts priced, invoiced, and paid in euros or US dollars. Fifth, implications of sanctions for contracts, force majeure clauses, insurance and reinsurance, and financing instruments. I'll give you a few examples of concrete acts related to this fifth situation. The EU Council decision of 25th February 2022, number 327. Then there are at least two Council regulations, the number 4228 and 576, one of March and the other one of April this year. And now I move to the sixth type of event, the destruction of ports and or closure of ports. And implications of skyrocketing prices of commodities such as raw materials for fertilizers. I'll give you I have just spoken to a colleague that is based in Brazil, and he was telling me about his experience. He does dispute resolution in agribusiness, and he tells me there's been a severe impact on Latin America, and especially in Brazil, because Russia and Belarus are together responsible for almost 40% of the world's production of potash, that's potassium chloride, that is a raw material used in fertilizers. And this, there's been a skyrocketing increase in prices, and there's been close to a 300% increase. And so it's difficult for especially the agro industry in Brazil, the farmers that produce soybeans and corn and rice in the center of the country, that they depend on the fertilizers. For instance, the corn producers, they have corns 3 seasons a year. And to be able to do this, they need the fertilizers. So I also can give you a few examples. He was telling me, he's called Rodrigo Gabardo. He's based in Curitiba, and that's a state that produces a lot of soybeans, for instance. And he tells me that his clients were sending money to pay transactions, and the money was stuck in the Swiss banks, so they weren't able to pay. So there is a series of non-compliance with the contractual provisions due to the war. And also the sellers, because the port, there's one port in Ukraine that was destroyed, and Belarus, they don't have access to the sea, so they used to use this port in Ukraine or the port in Lithuania, but it's closed because of sanctions. So they can't send the products, they can't ship. So I will now move to something that, having this in mind, I will move to the need for alternative resolution in this context. So as recalled by Yves de Hans, with whom I have the honor to work at my firm, international dispute resolution requires cultural, neutrality. In arbitration, for example, the area of my expertise, arbitrators need to set up a proceeding which is acceptable to parties coming from different countries, meaning that they have to free themselves of their own legal system and familiarize themselves with different national procedure laws. For emergency situations, it is true that rules of several arbitral institutions provide for emergency arbitrator provisions. These will be key in times like this. I know that GEM's international arbitration rules provide for emergency relief procedures. Finally, dispute resolution stakeholders should be aware that at times of crisis like this, they should be aware of the risk of cognitive biases, such as the one called the Maslow's hammer, also known as the law of the instrument, popularly stated as, if all you have is a hammer, listen, if all you have is a hammer, everything looks like a nail. As pointed out by Claudia Salomon, the ICC International Court of Arbitration's president. So as she said, conscious of our tool bias, like me, I do a lot of arbitration, so I tend to propose arbitration to my clients. But we have to dig deep in our toolbox, because there are various ADR tools to be used, and depending on the situations, these will be better or less good. So so that we can create procedures that are adapted to the case, and that they should be tailor-made, not following standards and models. But mindful of time, I know I am here, and thank you for your attention.
Thank you, Anna. Really interesting. And I will be handing over to Francis in 1 second. Just before I do that, I just want to draw attention to the polls that we've had so far. We had an interesting, almost exact split between mediators and arbitrator, mediation and arbitration experience, and we've got people with a whole range of different practical experiences. I'm just going to, in the chat, pop in a question, which is, if you wrote other in the poll, in either of the polls, would you write in the chat what additional processes you have experience in? So is that expert determination or early neutral evaluation or something else? We'd be interested to know. I know that a lot more of you have used Ombudsman, apparently, or been involved in Ombuds processes than we've got Ombudsman on the call, but we've got 3 there. So interesting to see. I'd love to know where the Ombudsman are from, if you're if you're willing to share that with us. So 2 questions there. What other processes have you had experience in? And if you're an ombudsman, where do you come from? So, Francis, may I invite you to pick up the baton at this point from Anna and take forward the conversation. Do we have Francis?
Yes,
we do.
I'm unmuted.
Wonderful.
Right. Now, I think in Asia, what we've seen is 2 big things that I want to share quickly. And the first is that you talk about pandemic-driven disputes, supply chain disruptions. And what we've seen is a huge resort to mediation in those disputes. And I think that's been caused by a number of reasons. Number one, I think there is a sense that the enemy is not across the table, but there is a common enemy in the form of a very tiny virus. And I think in a number of countries, including Singapore, legislative mechanisms promoting the use of out-of-court or out-of-arbitration settlement or resolution, quick resolution dispute mechanisms in tenancy situations, construction issues, supply chain situations have been implemented. But quite apart from that, I think the pandemic-driven disputes, many of the people suffering from the strain have had their cash pipeline disrupted. And frankly, there is a serious realization that if one were to rely on typical concepts across the civil common law like force majeure and frustration, you're really facing a very, very uncertain outcome. So all of that may have caused a huge shift of these disputes, not towards arbitration or litigation, but to mediation. Now, we are also seeing that same trend, not only for pandemic-driven disputes, but also disputes that were there even before the pandemic. We are seeing that across international commercial disputes. We are seeing that across investor-state dispute resolution. So resort to mediation, there's been a huge shift from what we can say over many, many jurisdictions in Asia. Part of it, we think the impetus for that, part of that could also have been the Singapore Mediation Convention, Isabel, that you raised some time ago. Currently, as at mid-July, we have 55 signatories, but I think beyond that, there has been a sense that mediated settlements are going to be enforced in a big way. And so there has been a huge shift to mediation. What is the lesson, the first pragmatic lesson for all of us here? I think with the rise of straight mediation and hybrid processes like ARB, MED-ARB, even if you're an arbitrator, and I saw in the last poll that about 26% of the participants here have experience in mediation, whereas the large majority have experience in arbitration and other processes. So I think it's very important that all of us become accredited mediators for a start, right? I think that's where the world is moving to. Even if you're an arbitration specialist, you may be called upon to be part of a hybrid process. And if you have arbitration accreditation, but not the mediation, you're just going to be left behind. Now, the second big thing I want to talk about in the little time that I have here is we've seen how important it is to be nimble as a practitioner, whatever you call yourself, right? I've seen the chat, a number of people describe themselves differently. You've seen how borders are porous. With the pandemic, we've learned that money and people are no respecter of national boundaries. So at a time when Singapore and Hong Kong remained closed, we saw a huge outflux or influx of money into the UAE because the Dubai resolutely remained open. Today, when Singapore is open and Hong Kong is not, we are seeing all across Asia, disputes cannot be resolved. So the virus, this tiny microscopic virus, has disrupted the functioning of dispute resolution centers and the modes of dispute resolution themselves, right? So many of the disputes that typically would be resolved in Hong Kong can't be resolved because people can't move in and out. And the reality is, when other jurisdictions are open, people do prefer hybrid processes as opposed to completely virtual processes for various reasons I need not go into. Many of you would be expert in that. So I think it's very important. For instance, I get asked all the time, very frequently, where would we go if we do not wish to go to Singapore? If clients are happy to go to Singapore for whatever reason, that's fine, right? But if for some reason Singapore is not appropriate, right? They could go to Hong Kong before. Now, and perhaps they don't want to go to Paris. Where could they go to? So Thailand. Now, it becomes very important for you to understand the different situations in Thailand for dispute resolution, in Kuala Lumpur, in other parts across the world, so that you are better able to advise clients and be nimble in your approach in the face of crisis. Back to you, either Nikki or Isabel.
Thank you, Francis. Wonderful. Some really specific suggestions, ideas there. And thank you for picking up some of the poll results as well. I see that we've got conciliation and ombudsman coming out there as two of the key additional processes that have been mentioned. So thank you. Now over to a different context again. Victoria, can I hand the mic to you virtually?
Yes, thank you so much, Isabel and Nikki and everyone. It's a pleasure to be here from a non-legal perspective to talk about DR. And just as you mentioned, Isabel, the EBRD, as many of the multilateral banks, funds projects seeking to ensure sustainable development in different countries. For the EBRD, we're operating in 39 countries nowadays, promoting the transition to market economies or to more democratic entities. And in those cases, we usually find that there are environmental and social impacts that cause harm to communities. And to address those conflicts that are arising, my office is responsible for going forward with dispute resolution processes to try to address the conflict, and with the overall objective of ensuring that the projects are sustainable. So in that sense, it's important, taking into what Anna said and other comments, we're not neutral, yeah? And we're not impartial. We really have a clear objective where we're going towards. But other thing that is really interesting, and I was listening to Francis on the challenges brought in by COVID, is who is one of our parties? The parties are those communities, the most vulnerable in every country that we go in, who have very limited access to legal processes that even fear them enormously, and that have this imbalancing capacities when having to confront a large company that is building a hydropower plant somewhere, or against the bank itself, but that they do not know that they're being harmed. So this brings in, from my perspective, a new view of what dispute resolution works about. For us, definitely COVID has been the most disastrous phenomenon that has happened in dispute resolution processes, because our communities do not have access to virtual mediation or things. They do not trust you either. You're talking to communities that are in the middle of a rural area, and you're trying to build onto your own urban-like process for them that doesn't work. And then talking to 39 different cultures and way of approaching, either if it's culturally or religiously, or as regards the openness of their country to voicing concerns. So that brings a new way of how we operate. We also try to strive as much as possible away from legalistic visions of dispute resolution. We're addressing concerns. We're trying to level the playing field for people who are to understand what we are doing, and that we're really seeking to address their concerns in very simple ways, where the other party never considers that their concerns are legitimate, which is also really interesting. As I think, Isabel, you mentioned early on, well, we have the Ukraine war, we have COVID, but we're now seeing challenges in water availability in many countries. My experience in Latin America and the Caribbean, the conflicts on indigenous peoples, on really having access to health, all these different elements are common to every country. And we're seeing that this is rising in volume. So, and also a preference for, yes, dispute resolution processes, but something that moves from just reaching an agreement to really seeing an agreement being effectively implemented within the timeframes that make sense for the livelihoods of people. So I think we're all talking about the same thing, but just very different perspectives. And I'll leave it there so that we can go into the questions. Thank you so much for the opportunity.
Thank you, Victoria. I think in different ways, you've all brought out exactly the way that these sorts of crises shift how people need to do things in order to keep commerce going, and how or what within legal context actually becomes more or less important. There's one question that's come in the chat around force majeure, which has already been picked up in one of the presentations, and the shifts around, well, what's that actually going to lead to in terms of outcome, which links to some of Anna's points, where you've got commodities that have gone up 300% in price, you've got a completely different playing field. And of course, with communities that maybe can bring things to a complete halt in terms of what the commercial body is trying to do, in terms of how to engage with that, which brings again the importance of these different types of laws. So there's a couple of reflections for me. Nikki.
Yeah, I think there are a couple of really great themes that I'm seeing weaving through all of our discussions, and one of them I think is the need to be fully able able and capable dispute resolvers, to not only have the hammer in our toolbox, because Anna is right, if you're just walking around with one tool, you're going to have the same solution to every problem. And I think that was picked up in what Victoria was talking about, with the need to really understand the kind of conflict and the kind of individuals and the access and the building of trust that's necessary to engage everybody fully in the context of these very difficult times. And then, as Francis was saying, the new tools and laws that are on the horizon to empower this kind of versatility of mediation with the Singapore Convention. We see a lot of things. One of the kind of interesting historical things about my organization as a dispute resolution services provider, most of our neutrals are arbitrators and mediators and facilitators. And so we're really keen on building those skills. And I think that the users are asking more and more for different entities to push the diversity and the variety of dispute resolution options. And I think that's one of the things that we can learn from these kinds of discussions is, what can we borrow from the different kinds of practitioners who are resolving conflicts in ways and with fungible skill sets that might be importable into the human rights context or the international law context or the commercial context. And I think also the other thing that I wanted to comment on was Francis's question of the way of thinking, like, well, if this doesn't happen, what next? When faced with an impossibility, I think everybody is understanding with this truly common enemy of say war or illness, that it doesn't make any sense to bring a million force majeure clauses, especially if all of the distributors and suppliers are in the same situation. So I think that's pushing dispute resolution and parties in conflict to think a little bit more broadly about innovative and more diverse options for finding solutions. I'd love to to hear some of the panelists' experiences with this new kind of flexible world. I mean, I know here at JAMS we've been the host where when people can't come to hybrid procedures where it may be seated in Singapore with parties from Korea and Brazil and New York and Italy, and this just happens to be a technological platform that we can offer, but really the law allows for flexibility to solve the new generation of complexities with flexibility and technology. I know I put a lot of stuff out there, and there have been some good questions coming in from the chat. Isabel, do you want to pluck something from the
One of the things that I just wanted to pick up, which connects to what you've just been saying, and I think connects to one or two of the comments, not specifically question, we'll come to that, is the issue of hybrid processes and dealing with the complexity that surrounds where there might be clear legal principles that could be applied in normal times, but it may be difficult. Certainly one of the things I've experienced in practice is that we all moved entirely online for a good portion of time, and now we're having to do hybrid, and Victoria's picked up some of the issues of that in relation to communities. Francis, you mentioned it, but there's also confusion between when we're talking about hybrid, are we talking about med-arb-arb-med, or are we talking about partly online, partly face-to-face? So the one that I'm just curious to get a little bit of insight to around these contexts where maybe the straightforward legal options are not as easy to take is the mixing in-person and online interaction. Any ideas or experience of that? Because in my experience, that's more tricky than being all online or all offline. It creates some very different problems. Any thoughts around managing that? Anna.
Yes, in one of my cases, it ended up that we had the whole hearing held virtually, but there was a moment when we discussed whether it wouldn't be a good idea to, because there were at some point during the pandemic, there were travel restrictions, and the travel restrictions were not sort of harmonious across the globe. So some of the parties were in Europe, and there were some experts in the Middle East. So, and there were stronger restrictions applying. So we envisioned at some point that having the experts participating virtually, since travel restrictions would be would not permit them to participate. But then it ended up that we held the whole hearing virtual. But I know that this has been going. I mean, and I have other colleagues that had the same hybrid. It works well too. And even before the pandemic, there were some times when there was an expert witness or a fact witness even that couldn't participate, couldn't make it to the hearing for various reasons, could be health reasons or unrelated to the pandemic before. And we used to have like someone participating via a video conference. So that, of course, now it's become the norm. And quite often in procedural situations, in our cases, normally we have this we try to save costs and time, so it's best for the parties and for counsel. So in the end, we encourage having discussions virtually, but at some of the cases, they are high-stake cases. Sometimes the parties prefer having in person, and now that travel restrictions are less important, at least in Europe, it's become back. We were going back to physical hearings or hybrid hearings.
Indeed. And that's great where it can happen. Victoria, as you said, some of the places that you're working in, it's simply not ever possible to get people online.
Yes, and I'm seeing one of the comments there that virtual is faster and cost effective, and it's given me really a point that I would want to discuss with you all. Is it all depends on the context of where are you working, with whom are you working? Because I'm just finishing one dispute resolution process that we have had to terminate because there was a risk of retaliation given the imbalance of power, but the fact that we were not there to early on establish conditions to really be clear on what was the contextual risk for our complainants, really made the complainants decide that it was better to back off and not face the risk of not being, this was a labor dispute, and to be expelled from their jobs or to be fearing for their livelihoods. So for anything, in deciding what works best, I think we have to do a good assessment of the process, of the dispute resolution process, of the likelihood of that conflict being able to be addressed in one way or the other, and also seek what's the preference of your parties, how comfortable they are on this. For us, for example, we always have to be working on with interpretation. Is that something that is working well? Is everyone understanding the issues? Is the interpreter really being good enough to reflect exactly what we're doing? And how much trust does your your parties have in you, that they're willing to engage in that way? Or do you have to build first trust and then you can go virtual for minor things? So it's not a fit for purpose for everyone. I mean, you have to do a bespoke thing, I guess, in many times. And sometimes it's good to go on virtual. Others, you can have a mixture of things. And sometimes you really have to be there to be able to address it quickly and effectively.
And also in terms of how comfortable people and how people are able to engage. So I'll just give a brief example before I hand to Francis, who I think has also interesting experience in this, of just a banal thing that I'm sure that all of us have done, of being in a meeting with 4 people around a table and 2 people on screen. And the camera's not angled so that the people on the screen are looking at somebody at the top of somebody's head or a blank wall for the duration of the meeting, and they can't really participate. And if that's happening in our developed context where we've all got access to webcams and so on, the difficulty of involving a large number of people or people without stable internet connection or whatever. So I think it's something that's in some of these contexts is because of the commercial context, and particularly once it's commercial legal context, people aren't always don't always make that jump as to what the experience is like for the people on the other end who are staring at the blank wall in this wonderful virtual process, right? Francis.
3 lessons from the pandemic, Isabel. First, we were all surprised at how effective a virtual hearing could be, even when you're cross-examining or hot tubbing expert witnesses. Second lesson, for the key parts of the case, we all realize that an in-person hearing is still more advantageous because, watching a screen, you get screen fatigue. It is not personal. You feel detached from the whole process. There are time zone differences. Today, we live in a truly global dispute resolution mode. So if you have an arbitrator in South America and Brazil, and then you have a counsel in Japan, you have a very small window to operate, right? And your hearing is likely to start at 8 p.m. and end by 1 p.m. or something like that, 1 a.m. It doesn't work. And there is also a greater license for people to try and game the system using other devices, all kinds of signaling that may not be picked up with the cameras. And so I think we are truly in the hybrid world. But the third lesson we've learned is that because virtual is effective, as Victoria has said, horses for courses, if you have a case with 20 witnesses, maybe only 8 of them you really need an in-person hearing. The rest of them are minor. You can increase efficiency and save costs and time by having the minor witnesses do it on a virtual basis because they're really talking about documents and maybe one of them is very far away. So really it has given us a tool to use judiciously to cut costs and time. Back to you, Isabel.
Thank you. And I'm going to pick up now on something which Raja has also picked up on. We've been talking quite a bit about geopolitics and so on, and so I want to bring it back a little bit to the context of the civil commercial law and international law, and just draw attention back in that direction a little bit in terms of I mentioned it in the introduction, things like the Singapore Convention. There's a question around the New York Convention, but the whole question of enforcement and the shifts in attitude towards some of these state-to-state based treaties and enforcement of those in this context of upheaval, and maybe some reflections from you on how either the legal practice is changing or the law itself is changing in relation to that, given the difficulties of, for instance, getting enforcement in the context of armed conflict or war, which is obviously Ukraine has been particularly noticeable and particularly important, shall I say, in Europe and maybe the States, but there are a lot of contexts. Many people are calling in from various places where armed conflict and or war in various forms have been ongoing and are ongoing, so dealing with something all the time. So maybe, Francis, given your experience in the investor-state context, maybe there's something around that you could pick up.
Well, Isabel, I think enforcement, and there was a question also from a number of the participants on enforcement and the difficulties with enforcement. The fact is, even though there are many signatories to the 1958 New York Convention or the ICSID Convention, the fact is enforcement poses grave difficulties across the globe, because ultimately you need a national court to do the right thing. Right? And we have different cultures, we have different perspectives, we have different public policy loopholes or different ways we look at it, such that there are enough challenges to uniform enforcement across the world. And this was, even without taking into account a crisis of the kind, Isabel, that you're talking about. Now, when you add to that, right, all sorts of crises that's being discussed, then it really becomes a very rowdy atmosphere. Right? Because it adds a complexion where the normal functioning of national courts the normal functioning of enforcement mechanisms, the normal functioning of state-to-state cooperation is simply eroded. And so I think the fact is we live in a very divided world, and conflict upon conflict just makes it all the more difficult for us to pull together in a harmonious trend. So the difficulties in this area we are seeing have just become even more, acute. And that's the reality.
And I suppose that's one of the areas, or one of the motivators behind your statement that mediation is increasingly popular, and increasingly the way sort of seen as the way forward. And it raises for me an interesting question in terms of international law around the Singapore Convention, which for me has always been a question, because though the statistics, the data on this is very, very poor across the world, and if anybody on this call is aware of good quality data on this, then please do let me know, I'll be fascinated. But there's very few jurisdictions that have followed and published any information about how many cases that have been mediated, have reached a settlement, have then gone back into court and been taken for enforcement. Because the way that in many jurisdictions that's tracked, it's impossible to track it, because they simply end up as a settlement that's lodged at the court, and whether it's mediation when it's not clear. So you can't actually see what's the enforcement rate on mediation cases. Anecdotally, mediators tend to say that mediation very rarely has to go for enforcement because it's a consensual agreement, right? So that raises an interesting question about the Singapore Convention, specifically in international legal terms, is its strength actually that you can enforce, or is that not in a sense a sort of sidetrack? Because if parties have come to an agreement, the reason for enforcement is much lesser than in a context where a third party has decided and imposed a solution, such as in arbitration. So that's, for me, quite an interesting question around the function of that international law, as opposed to the practical, maybe even slightly more pragmatic world of the civil commercial context. So back to Francis.
Just
Nikki,
a quick report to that, Isabel. Just remember, even as at mid-July, 55 signatories, but only 10 countries have ratified the convention, right? So the convention apparatus infrastructure is only being put up. So I think we'll have to wait a while before we get to a concrete example. Isabel.
Yeah, and for that to actually be tested could take several years, given if the expectation is that actually enforcement is not the biggest problem, it's people getting at people actually into mediation. Anna.
Thank you, Isabel. Yes, I tend to agree that it will be an important thing to have more contracting parties ratifying the Singapore Convention, but this might take some years. But it's true that I agree that with mediation, normally the parties agree, so I would imagine that they would comply with the solution, or they would implement or enforce or not enforce. There would be no need for enforcement. They would simply execute their agreement and comply with it. Whereas in arbitration, I must also recall that most awards are complied with. So it's not that every time we have to institute enforcement proceedings before state courts. But of course, the one thing that is very difficult, and certainly Francis was referring to that, is enforcement against state entities and sovereigns. This is really difficult. But normally, I think between private parties and dispute resolution, normally parties, I'm pretty sure that the majority of parties comply with arbitral awards. But of course, there are some jurisdictions where it could be more complicated. There are more litigious jurisdictions. And I must say that I speak for Brazilians that often apply for a request for interpretation, and then they institute set-aside proceedings. I used to work with Arnoldo Valdo in São Paulo for 6 years. When at the time I was there for 6 years working with him, and he used to say, "I'm not doing setting aside proceedings." He was really in favor of arbitration and refused the request. He said, "We go to another firm." But this is like a very special person, and and he was an enthusiastic of alternative dispute resolution. And as you know, in Brazilian courts, state court proceedings may take 20 years. so you want to be considering that when you decide what in terms of strategy.
Absolutely, that sounds very wise. I'm just going to take this opportunity to ask Katrina to launch our third poll, which just asks you a little bit about what professional background you come from, because obviously you can be a ADR neutral or participating in ADR in various ways, but you may come from all sorts of backgrounds. So really interested to see where you come from. And whilst you're answering that question, I'd quite like to pick up another element of the issue of international law with Victoria, which is, of course, the other side of the international legal world is the area of human rights law. And often in the work that certainly that I've done with communities in various contexts suffering from water distress and land use stress and so on, if you talk about law in that context and in international law, it's not the commercial context that they're thinking about. It's often the socioeconomic, collective developmental human rights that they're thinking about. And are there shifts or changes, or either in practice or in law in that context, that you think are relevant in these times of stress?
I think, yeah, you precisely have hit the head of the nail on that one, because most of the complaints that we receive are very much related and presented as human rights violations. In the context of a financing contract, there's no even mention of abiding by any kind of international convention on human rights. And you will have the parties, either the bank or the client, are most of the time unaware of what these conventions include or say. And some of the countries either have not ratified them or have not transformed them into any regulation that could be clearly spelled out for what the client is supposed to be doing. But what we have seen nowadays is strong pressures from civil society organizations to ensure that the bank does follow human rights due diligence, making sure that you clearly identify the impacts and establish that the socioeconomic rights of the community are considered when evaluating a project, and determining whether that is being adequately avoided, the impacts addressed or compensated in any way. And as we were talking about the enforcement of agreements, I think what we continually see is communities are trying to shy away from courts. First, they don't have the money to file a lawsuit. Second, even if they have the money, their needs are today, not by the time a court can really get into that. And that's been a big problem everywhere in the world. So they come to us as an administrative function to try to see if redress and remedy can come in an easier approach, more directly to the concerns they're raising without all the process of following. And either in the public or the private sector, because we have been addressing both, you see different points of pressure that we can accept. On the sides of this can be the financing agreements, but also on whether you're willing to continue with a certain client if that client is not really is getting a lot of messy conflicts around, and therefore the projects cannot really take off. If projects fail because of the lack of understanding of the community and issues that are happening, or simply because the reputational risk for the bank is huge. We haven't mentioned this, but I think the whole DR process and the whole conflict situation in the world and the context has changed with the use of social media by those that are feeling the pressures of conflict. So that actually brings in a lot of leverage on, you're not abiding by an agreement, then you will be seeing yourself in the next Twitter campaign very soon. And then how does that proceed? Yeah?
Mm-hmm.
I just wanted to pick up on some of the comments and a little bit picking up on that last comment by Victoria about just thinking a little bit about the crucible that we're all in and the advancement and developments that have come to pass with the adaptation and the realization that sometimes technologies work, as Victoria mentioned, sometimes there's too much of a lack of access and trust for them to work. But just as almost a call to action for us to not lose the creativity and innovation that the really tough times have caused. I think that there were so many people, I think in the international context, we've been doing hybrid and virtual things for a long time, just because we are such a diverse group in many jurisdictions who work together, and the spreading of that into more context and the sharing of best practices and the advancements with that some of the people in the feed have been talking about, of ways to ensure a fair and good process without cheating and without hacking and without some of the concerns that we face every day. That's been a real boon, if you want to think about it, of the layers of crisis that are upon us. And there are so many technologies and solutions, even non-technological solutions, that are out there. As Anna was mentioning, the emergency arbitration procedures, as Francis was mentioning, maybe a list of different hearing venues or hearing locations, maintaining the venue for the legal reasons that you've selected that venue. So I just wanted to end with my comment with a little example of one instance where I worked with one of our judges on a eviction mediation track. And again, we were dealing with clients. This is the kind of pro bono part of some of the things that our neutrals do. We worked with a program in Philadelphia that was completely based on telephone. And there was huge skepticism at the beginning that there could be a kind of fair and full discussion just on telephone, since everybody was now used to doing Zoom and video. But actually, the percentage and rates of facilitated success were very high. So I think one of the things that we have to learn as a lesson is open-mindedness, and understanding how these critical situations can push the dispute resolution community at large to both come together and to push ahead. Oh, and I just wanted to address a tiny technical question about the poll results not adding up to 100%. When you have multiple option to tick multiple boxes, it won't add up to 100%. So we're not cooking the numbers. These are the actual poll results. And many of you, as with our speakers today, are multi-talented, and I think that again just goes to another underlying theme of having lots of tools in our toolbox for this.
Yeah, and given the variety of people we've got on the call there, and I see we've got quite a large percentage. In fact, one of the largest percentages are people from industry and commerce. And I'd be just curious if any of you who are in industry and commerce have particular questions or thoughts around to our panelists about what you see or want in dispute resolution mechanisms, and or your experience around dispute resolution and the law in the current situation. So please do keep those questions coming. There's one or two questions which I may be missing what the actual question is. I think Ola, the mediation can provide a way of balancing power without doubt. I think it's not wholly straightforward, at least I would say, particularly in my experience of situations of a related type to the work that Victoria does, where you're working with communities and multinationals plus government. It's quite an interesting question as to what extent you can balance power, and to what extent law, which is often originally sort of conceived as a way of sort of balancing power, interestingly, because the idea of everybody being equal before the law is essentially about that. But how that actually pans out in reality, and how as people involved in dispute resolution, we actually manage that. I don't know if Francis or Victoria, you have any reflections on your experience of situations where you've got such diverse parties involved in situations like that, and balancing power.
Yeah, I think obviously what you're trying to get with a voluntary process is for parties to be able to engage respectfully and listen to each other, which sometimes that party that has less power hasn't had the opportunity to achieve on its own. But we usually see that the imbalance of power comes on, obviously on one side on capacities to engage, but also on what is the consideration of the most powerful, of really wanting to listen to the other party or thinking that the other party is legitimate. So we work a lot on that part, how to present to both parties what is the area of mutual concern and how they're actually working towards a common goal, more than establishing positions of what they want each other, but rather seeing, that's why I said that we're not impartial, because we're both wanting to have the project happen in a sustainable way. And therefore, try to emphasize less the differences, which are huge in many ways, but rather what's the win-win there for us all in that one.
Mm-hmm. Yeah, finding there's any area of overlap of that allows people to be working on something together. It's quite a challenge.
Yeah, and if I can add, sorry to interrupt you, because you just said something that's really important. And it comes to a point, for example, when you're engaging a community with a government, and I had this case with indigenous people in Peru, the officials have never met indigenous peoples from the Amazon ever in their lives. So our process was the first time when they sat down, I started talking to each other as person to person, or as Peruvians, let's say, at that point. And they found that they had things in common, as human beings do. And then the preconception that each one carried as group against group started more into going to developing the relationship, which is why I really prefer things in person than virtual. And I've seen some of the comments there, because it actually builds on the relationship between one human being and another, and less on how do we solve this problem. The same we had with Haiti, with farmers and the bank where I was working. They had never talked to each other. They never thought about each other as families with kids and things. And suddenly they both were having the same problem. We couldn't sit them down because both had kids and the time schedule was not working for them. So that sort of thing is what we work a lot into getting that common rapport. Sorry.
No, that's really helpful. And I think I think the context I've worked where that gulf is so huge, it is very striking. It's very obvious, and it begs to be addressed. I think a context where that sometimes disappears a little bit more and causes problems because it's a little bit less visible is the context of people who are in government and people who are in leading positions in firms, in commerce or industry. And you've got professionals in both contexts, but their understanding of the world is conditioned by two completely different things. And I imagine that that's something that, again, these difference in what do you see as important when you think about law. You can have a complete, to use the fancy word, incommensurability of a public sector seeing the public law as being the thing that they have to protect above all, and the commercial party maybe seeing the private law issues as being the more important. Francis, Anna, this is more.
Yes, I should add, you were discussing negotiation and mediation, but I should draw your attention to the fact that in Latin America, dispute boards have been used very much in Brazil and now and Peru For instance, there's a very strong trend and many of very big infrastructure projects involving governments and private stakeholders. They've been adopting dispute boards as a step before going to arbitration. And the report I have from colleagues and myself, my own experience is that this has brought people, like the parties, opposite parties that were in a dispute together, and they helped have them having a better relationship and assuring the continuity of the works. So this is very key, and I think there's a nice trend especially in project finance by international banks. The international development banks require dispute boards.
Francis, did you want to add something?
Well, I mean, I think the landscape, the reality is that there is an imbalance of power, right? I mean, if you talk about the ISDS landscape, you have states and you have individual investors who invest in the state. And so the whole mechanism, infrastructure of ISDS is designed to provide an investor, a foreign investor, with recourse against the state, which has real teeth, right? And in a domestic setting, it's the same thing, right? You have national courts, you have legislation regulating the balance between the state and the rights of the citizens. So this whole processes of dispute resolution, one of the aims at the heart of it is to provide some semblance of equilibrium in allowing the man of the street or the individual investor who gets into a foreign state, a way to seek redress if his rights are trammeled upon. But obviously, it's nice in theory, and we've discussed in practice, many issues crop up, right? But, we all, I think most of us in this room virtually are in the space where we strive to make that equilibrium happen.
I think that harkens back really nicely to one of Anna's opening points about how we all work towards cultural neutrality, or at least supporting a neutral process coming from civil jurisdictions, common law jurisdictions, different languages. We spoke about the challenges of translations. And also, I think building in some of the questions about, how can we talk even about the Singapore Convention when it's so new? All of these things, as Francis said, start out academic, and it's just with years of practice and usage and improvement that we're able to kind of build them into more robust and strong mechanisms to help dispute resolution in whatever context it may be.
Yeah, and I think that we're going to be continuing this conversation and some of these questions. I'm conscious of that we've got a minute before we wrap up. So we're going to have a wrap up of the main part of this series in September. The date's not yet fixed, so I hope that you will allow us to let you know when that's going to be. And we're going to have one additional seminar in the series at the Chartered Institute a mediation symposium. That's going to happen on the 5th of October. I put the link in there, so please do sign up for that if you're interested. And we'll be looking at some of these questions around acute disputes and ongoing conflict, but specifically through the mediation lens. So some of the things we've been talking about and some of the things that we will that will be added. So I'd like to say a big thank you to Anna, to Victoria, to Francis, and to Nikki. And just to give the closing remark to Nikki.
Oh, thank you. I can't be exuberant enough about how wonderful this experience is to join you from all around the world, and for those of you who might be watching this on replay on YouTube, to be a part of the conversation. And as Isabel mentioned, this is a continuing effort, and we really hope that those of you who didn't get your questions answered will engage through email and follow up. And thank you again to all of our amazing speakers for sharing sharing your insight and experience. It's truly amazing to be a part of this global community of dispute resolution professionals and activists. Thank you so much. And hopefully we'll see you again on the 5th of October.
If not before, in September.
Yes, and for our culminating session for this series in September. Thank you so much.
Thanks very much.
Bye.
Thank you, everyone.
Bye.
Good day, good evening.